you know, it's ridiculous. It's like, how do you ever dig out from under it? And like, Washington doesn't care, they don't give a crap about y'all, or us, that doesn't matter, unless you make a lot of noise and tell them they ain't getting reelected, unless they do something about this, then maybe you'll listen. It's one of those really terrible practices. I just think it's criminal, but anyway. All right, so, let's talk now. We're ready to file your suit. You've got your lawyer and all that. If you're filing your suit in state court again, you're gonna call it a petition. That's what's going around. You can look at that. If you're filing it in federal court, for whatever reason, they call it a complaint. So what does a lawsuit look like? Well, I hope most of you have been able to take a quick look at this. You can kind of verify what I've been saying. So at the top, you put the caption. You put the name of the plaintiff versus the name of the defendant or defendants. You put the name of the court where the suit's going to be filed. You entitle it petition or complaint. And then you essentially, up front, you have to tell the court that the court, this is the right venue and that this court has jurisdiction. You have to tell the court under what law does this court, where I'm filing my suit, have the authority to hear this kind of case. So you allege jurisdiction and venue. Then you name your defendants. And you have to say where the defendant, what parish or state the defendant is a resident of. So in this case, blank, made defendants herein are blank, a person of the full age of majority, that's like, stupid lawyer phrasing, and domiciled in the parish of Orleans, state of Louisiana. You gotta tell the court where the defendants live, so the court can decide, does it really have jurisdiction over this defendant? And are you really in the right venue? Okay, so you lay that out, then you lay out the facts, what happened in this case. Then you tell the court what the law is that should be applied to the facts in this case. Then you ask for the relief sought. What remedy do you want? Most of the time in a civil suit, that's going to be, I want money. Well, what do you want money for? So here, this was a personal injury suit. Here, the plaintiff is asking for damages, including the following: for her past, her present, and her future physical pain and suffering. For her past, her present, and her future mental pain and suffering. Sometimes referred to as mental anguish, emotional distress. She wants her past, present, and future medical bills paid. And she wants her past, present, and future lost wages, or she wants a big chunk of money for the loss of her ability to earn money. Because before the accident, she was able-bodied and able to work. After the accident, not so much. So the person who caused the accident is responsible for all of those kinds of damages. And then at the end, you have the paragraph normally known as the prayer. It's not really a prayer. But that's what they call it because we use the old archaic English terminology. Plaintiff prays that the defendants be served with her lawsuit, that they be required to answer it, and that after all the proceedings are finished, plaintiff wins a judgment against these defendants in favor of the plaintiff for telling them to pay plaintiff all the money they owe. That's the conclusion. After that is done, so your petition is going to be filed with the clerk of court in the appropriate court. Whatever court you file your suit in, you go to the clerk's office and file it and pay your money. There will also be a sheet of paper that you will be issued called a citation. That, if you've ever been sued, if you've ever been sued, the citation is that cover sheet that comes on top of the petition. And it says in all caps and bold letters up at the top, you have been sued. Yeah, nothing anybody ever really wants to be handled. But that's what the citation is. So, next thing that has to happen is the lawsuit has to be served on the defendant. Service of process is just a word for legal papers. So service of process. That is not left up to the imagination. In other words, there are very specific rules about how a defendant who is being sued must be served with the lawsuit. If you don't properly serve the defendant, for example, if you stick the lawsuit under his door at home, that is not good service. Even though that person may have actually gotten the lawsuit, came home, he saw that paper laying there, and picked it up and read it, he knows he's been sued. But that is not proper service. Therefore, he doesn't have to do anything. Because unless the plaintiff serves the defendant the way he's supposed to be served under the law, the defendant can ignore the case, ignore the suit until proper service comes back. So what is proper service? Well, first of all, it varies from state to federal court. Federal courts have made it much easier in the last 20 years or so. In federal court, you can actually serve a lawsuit by mailing it to the defendant. But it has to be accompanied by a few other documents. But if you do that, if you're the defendant and you agree, you have to waive service. One of the other documents is going to be a form where you say, I know I'm entitled to be served with this lawsuit by the United States Marshal, but really, I'm good. I'll take it in the mail, okay? I don't need a U.S. Marshal coming to my house, right? I got it. If you agree to accept service that way in federal court, you get a whole bunch of extra time to file your answer in court. So that's sort of the benefit of it. And of course, it's very cost effective for the plaintiff just to stick it in the mail. But also in federal court, if the suit has to be served in person on someone, then anybody over the age of 18 can be appointed by the court as a private process server. And then barring that, it used to be that the U.S. Marshals served all federal lawsuits. They too, like their bosses, the federal judges. Sonny, don't you dare go back and tell them we're talking bad about federal judges. Yeah, they don't want to do all that anymore either. So U.S. Marshals almost never serve lawsuits anymore. You have to go to the judge and get them appointed and all that kind of stuff. In state court, the sheriff in the parish where the suit is filed is the person who will go out and serve that lawsuit on the defendant. It gets a little more complicated if the defendant lives in another parish than the parish where the suit is filed, which means the sheriff's office in the parish where the suit is filed, let's say Orleans Parish, has to send a copy of the suit to the sheriff's office in Jefferson Parish, if that's where the defendant lives. And the Jefferson Parish Sheriff's Deputy goes out to the defendant's home or workplace and serves the lawsuit. So, a couple of ways you can serve it. Personal service means you basically put the lawsuit, the citation, and the petition into the hands of the defendant. But there's also something called domiciliary service, which means the person serving the lawsuit may go to the defendant's domicile, that is his legal residence, and he can serve the lawsuit on the defendant simply by leaving the lawsuit with anybody who is 18 years of age or older and who lives in the same house as the defendant. So, that comes in handy sometimes when you got defendants who are ducking service, right? For example, past due child support. I know that B is coming after me for all that money and I don't want to pay it, I ain't doing it, so hey, I'm like laying low, right? So my doorbell rings and I'm not expecting anybody, peeking out the curtains. Oh, sheriff's deputy car out there, no, not answering that door. Forget it, right? So that happens a lot. People will dodge service.
And you said they have to be 18?
Yes, so in that case, if the sheriff can go out and the person they're trying to serve is not at home, but someone else who lives in the home answers the door and that person's over the age of 18, you can serve the lawsuit on the defendant who is not at home by leaving it with that person who lives in the same household who is over the age of 18. That's what we call domiciliary service. Sometimes, yeah.
Do they have to be handed it to the person?
Yeah, that's what you want to
What
try
if
to
they
do.
don't take it?
Yeah, if they don't take it, you can throw it at their feet.
Really?
Yeah,
Oh.
yeah, because that's another game. Ooh, you're not serving me because I'm not putting my hand out. You know, really, at some point it gets absurd. So you can, there are cases that say you can throw it at their feet.
So like
You
if
can
they
serve.
touch it or?
Well, I don't care if they touch it or not.
Like
Look,
if
dude,
it's just
I'm
there,
leaving
so-
it with you. You're the guy on here. I've done everything right. You're gonna play this game, you're not gonna hold your hand out? Fine, there it is. You've been served. Yeah.
Is that where the expression slapped him with a subpoena comes from?
It could well be, could well be. And then, of course, after whoever serves the lawsuit, they have to fill out a little form and go bring it back to the clerk of court, and that goes into the record of the case, swearing, I, Sheriff's Deputy Joe Blow, on such and such a day, made personal service or made domiciliary service on this defendant. They gotta sign off on that. So you can prove to the judge, the plaintiff can prove, judge, the defendant has been served with this lawsuit.
There would be no witness, but they'll just take.
No, you don't need that. I mean, if the person's serving it, they basically swear out an affidavit saying, I served this person at this time in this particular way.
Yeah, but it couldn't be disproven anyways.
What's that?
It couldn't be disproven that he did.
No, not really. I mean, if, you know, unless you could show this process server or the sheriff's deputy's a big fat liar and, you know, good luck doing that. I mean, I don't know how you show that, prove it a negative.
As a plaintiff, you couldn't serve the defendant yourself, like a lawyer?
The plaintiff should, lawyers never want to do this, but, yeah, theoretically. So here's the other thing I was gonna say. Let's say, you got, the sheriff's deputy's gone out to this person's house and his place of business, and he's somehow never home, he's never at work. Sheriff's deputy says, look, I tried 3 different times, I can't catch him. So what I've done in the past, and what everybody does, is you then file a motion with the court, and you say, sheriff's deputy, sheriff's office has informed me they've tried to serve him, they can't catch him. Judge, I'm asking you to appoint Joe Blow as a private process server, so I can let him go serve. So here's how it works. Anybody over the age of 18 can be a private process server. So I had a case once where I was trying to serve this guy, and he was playing, tap dancing around, and never answering. So I finally got my nephew, who was like 20 at the time. The guy worked at a car dealership, sold trucks, and I said, so Josh, I need you to put on your jeans and your best kind of like, you know, college boy attitude, take this petition, this citation, go to wherever the car dealership was, ask for this guy. I said, now, anybody that asks for him, he may be suspicious because he's clearly dodging service, right? He doesn't want this lawsuit served on him. I said, so if they ask you, well, can somebody else help you? You know, say, no, you know, my good buddy was in a couple of weeks ago and talked to this salesperson, and he really recommended him, said he did a great job kind of running down all the trucks for him, so I'd like to deal with him. Is he here? Yeah, I'll call him. Guy comes like, hey, what's up? Shaking hands. There's a lawsuit. Damn, he had it covered. You can do that. And then I have to draw up an affidavit for my nephew to sign saying he served this guy at his place of work on a certain day, at a certain time, yada, yada, yada. And that's, you know, that's basically how it works. I mean, it's really frustrating when people dodge it, but then again, you know, you're getting sued, you don't wanna play this game, right? So if you can avoid it, you will.
What's the
Now-
last resort for?
Say it again?
What's the last resort? Did you will get a judge to order a person to appear, like a
That-
bench warrant?
Yeah, no, I mean, you gotta get them served. The last resort is a private process server. And if you gotta hire somebody to sit out in front of his house until you catch him coming home from work one night, then that's what you gotta do. Usually it doesn't get quite to that ridiculous point. Question?
I work for a software company and we do construction liens.
Uh-huh,
So we constantly
Yep,
And if they try 3 times, then we can fill out an affidavit of non-service. Or
Right.
they can just post it on that side of the house.
yeah, if there are some laws in certain areas of the law where, if you say, I tried, and I couldn't get them, you get some relief, but it's not gonna be a lawsuit for them, it's gonna be more like what she's talking about, a lien affidavit. So here's the other thing, if the defendant, I've been talking about defendants who are really like individual persons, right? If the defendant is a corporation, however, or an LLC, or a partnership, or any kind of business entity, there is only one person or company who can receive service of process for a corporation, an LLC, partnership, whatever. And that is whoever that corporation has appointed to be its registered agent for service of process. So how do you find out who that is? Well, you go online these days to the Louisiana Secretary of State's website. You click on search business filings. A field comes up, you type the name of the corporate defendant, or the LLC, whatever it is, in the search. You click on it, and it pops up all the basic information about this corporation. Where is its principal office? Where, is it a Louisiana corporation or an out-of-state corporation? Who is its registered agent for service of process? A lot of times, it's just somebody who's, an owner of the company. It might be the CEO, it might be the CFO, it can be anybody, it can be a receptionist, but that person has to be listed as the registered agent, and that's who you have to put the lawsuit into that person's hands, or it's not service. So if you're suing a corporation, you can't just show up at their office and leave it with the secretary, unless that secretary is the appointed registered agent for service of process. There are also companies that do that as a business. There's a big corporation called CT Corporation. They operate out of Baton Rouge, and their only business is they are a registered agent for service of process for a gazillion big companies and corporations nationally and internationally who get sued in Louisiana. So you send it to CT Corporation, or you serve it on CT Corporation. They then turn around and send the lawsuit to whoever their client is, whoever they are the registered agent for. Prentice Hall, the publishing company, they have a division that does nothing but act as registered agent for service of process for these big corporations all over the world. And then so you serve it on the registered agent, it's then the registered agent's job to get the lawsuit actually to the company so they can get it to their lawyer so they can file an answer. Question?
Does the registered agent get served in the same way as a private individual?
Yes,
So
exactly.
what in the case says the registered agent is unreachable due to, for instance, being out of the country?
I don't know, I've never really run into that problem, but
I would find that to be a elusive way to loophole the system.
yeah, it probably could, but most of here's the difference. When you're suing corporations, you don't get that runaround, that tap dance crap. They know they're gonna get sued, they're big companies, they get sued every day, all the time. Their registered agents aren't gonna play those, let me go to the bathroom and tell them I'm not here stuff. That just doesn't happen with companies. That's Mickey Mouse crap that goes on with individual defendants, but registered agents know that's their job, so you sign for it, you take it, that's the end of it. But it does have to be done the same way, that's exactly correct. Okay, so, after you get the defendant served, the ball is now in the defense court, they gotta file an answer. They file, in most cases, what we call an answer, in which they are also going to state what we call affirmative defenses. Affirmative defenses. So that means stuff like, so if you looked at this document, you'll see that the answer, for the most part, answers are deny, deny, deny. The allegations contained in paragraph deny. You don't wanna admit anything if you're the defendant, right? Cause if you admit it, you're stuck with it, right? And you don't know what the evidence is gonna end up showing, so your lawyer's gonna tell you we're basically gonna deny stuff. Now, you can't deny things that are undeniable, like, you know, paragraph 1 says I live in Jefferson Parish. Deny. Except I really do live in Jefferson Parish. You gotta admit that, okay? And generally lawyers know how to do this stuff. There are ways to sort of tap dance around it. But in this, example, if you see first defense, second defense, third defense, those are the so-called affirmative defenses. That stuff's a mess. Those are affirmative defenses. So one would be, in this case, the first affirmative defense is the plaintiff's injuries and damages, if there are any, were caused solely by the actions or omissions or negligence of somebody else, not me. Right? That's an affirmative defense. She may be hurt, but I'm not the guy that did it. I'm not the one responsible. The plaintiff is partly responsible for her own injuries. That's called comparative negligence or contributory negligence. Another one would be, whoops, plaintiff filed her suit too late. She had 1 year to file the suit, she filed it on 1 year and 1 day. Too late. If you can prove that, that suit goes out the window. Okay? So that's essentially how that's done. And let me just make this one last point. If the defendant doesn't file an answer or respond in some way, there are certain motions you can file before you file an answer. No, I'm not gonna hold y'all responsible for that. But if you just say, I don't wanna play ball, I'm not doing anything. Yeah, I got served, fine, do what you gotta do. Defendant does that at great risk. Because what's the upshot? What can a plaintiff then go and do? Not summary. What do you call it in b-ball when the other team doesn't show up for the game? Forfeit or default. You lose by default. We call that what happens if the defendant says, I'm not playing, I'm not answering this lawsuit. The plaintiff can go into court and get a default judgment, a judgment by default. That means, judge, I sued these people. I served them properly. There's no question. They haven't answered the lawsuit, so give me a judgment in my favor. The judge doesn't just sign a piece of paper. The plaintiff's gonna have to come into court one day and put on all of her evidence in front of the judge before the judge will give you that default judgment. But the beauty of that is, yeah, you gotta go to court, you gotta put on your show, you gotta put on your case, but there's no opponent, right? There's no lawyer for the person you're suing who's gonna be asking you questions or shooting holes in your case. So it's a slam dunk most of the time. You get a default judgment, that means, yep, I win. You didn't show up, now I'm gonna serve you with the judgment, and now I'm gonna do what I need to do to collect my money. And we'll talk about all that next week. Who had a hand up? Yeah.
How would one define themselves between an improper serve and a default?
Improper serves and what?
And, default, correct?
Oh, default.
Yeah.
Yeah, well, if you haven't been served properly, you can come in and say, Judge, don't let this case go any further because they have not properly served me. And you can do that. Because again, even though you actually know about the lawsuit, if they served it to you by leaving it in your mailbox, for example, that is not proper service. So you don't have to pay. So you get a lawyer, and the lawyer's gonna file what's called an exception of improper service. And the court will say, usually they don't throw the suit out, they just tell the plaintiff, get him served the right way. And you got 15 days to do that. If you don't, I'm throwing your lawsuit out. That kind of thing. All right, y'all.